Our next panel is on legal remedies, which seems quite fitting after the previous panel. Our first speaker is Professor Goodwin-Gill, who needs no introduction, certainly to most of us, but just in a sentence or two, I will say that he's a Professor of International Refugee Law at the University of Oxford. He is also a barrister, member of Blackstone Chambers. He has extensive experience with UNHCR. He's worked with UNHCR for many years. He was also the founding editor of the Journal of International Journal of Refugee Law. And I will hand over to Guy now.
Thank you very much. I'm delighted to be here. And I think you couldn't have picked a better subject and a better time. I wanted to talk briefly today about the Jeddah case, about deprivation of citizenship, and in particular about international law. As some of you may know, I was one of counsel in Mr. Jeddah's case, beginning with the hearing before SIAC in 2008. It is funny how we all seem to have a story about meeting Jay. I then drafted the ground of appeal to the Court of Appeal, but stepped out of the case until I came back in again last year in the Supreme Court, which was actually quite interesting. As you know, Mr. Jeddah was a refugee from Iraq. He was granted refugee status and asylum in the United Kingdom, and in due course became a British citizen. When he was in Iraq, as you have also heard today, he was detained by the British military on suspicion of having been involved with those who were smuggling or allegedly smuggling explosives into the country for use in IEDs. He was held for some 3 years or so, and more or less simultaneously with his release, he was informed that he'd been deprived of his citizenship. And the first hearing before SIAC in 2008 was indeed a challenge to that deprivation of citizenship. Of course, there are many other cases involving Mr. Jeddah and other aspects of his life. The government in SIAC argued that Mr. Jeddah had recovered his Iraqi citizenship, and they relied upon laws introduced by the Coalition Provisional Authority, in particular was known as the TAL, Administrative Law, which allowed us to argue that occupying powers can't do this. And there was an interesting dimension to the case that we were able, amongst other things, to quote Professor Greenwood against the government, Professor Greenwood, being an expert on international humanitarian law, has pointed out what occupying forces can and cannot do. And one of the things they're not supposed to do is change the nationality law. The reason why the Coalition Provisional Authority changed the nationality law, one of them, was that many of those whom the Americans wished to install in power had, unfortunately, acquired other citizenships. And under Iraqi law, the simple fact of acquisition of a foreign citizenship meant that you lost Iraqi citizenship. There was nothing political about it. It was an operation of law. And that sort of provision is not all that uncommon. Many countries in continental Europe had that sort of law on their books. So it didn't reflect any necessarily political intent, although there were also political denaturalizations. Now the SIAC, the best thing that we managed to do, Richard Hermer and I, was to stretch what Mitting hoped would be a morning's hearing into 2.5 days, but we lost in SIAC. But then the Court of Appeal stepped in and overturned his decision, sent it back for rehearing before another panel, which also found against Mr. Jeddah. But in the Court of Appeal in 2012, a reluctant body of judges, panel of judges, did conclude that Mr. Jeddah had automatically lost his Iraqi citizenship on getting British citizenship, that he had not automatically regained his Iraqi citizenship under the TAL or under the 2006 nationality. Well, that's because there were various conditions which needed to be satisfied, discretions that had to be exercised, and there was no evidence that had happened. And so we ended up with the Secretary of State appealing what was really an unappealable decision on the facts, but managing to wangle her way into the Supreme Court, where she changed tack to some extent, and she argued that she could be satisfied that her decision to deprive of citizenship would not render Mr. Jeddah stateless if there was another nationality option. If, for example, he could apply in Iraq, and if he would or might be granted citizenship. And thus the court, in a very summary way, dismissed these arguments as unrealistic. The simple questions at the court: does this individual possess another nationality at the date of deprivation? If not, then the effect of deprivation is to render him stateless. And the alternative argument, said the court, was a gloss as substantial as it was unwarranted. You might have thought that would be an end to the matter. Oh no, it's not. Let's leave Al Jeddah for the moment and move to what I think is nonetheless important from a slightly different perspective, and that's the United Kingdom's role historically in combating statelessness. And it has been, in the past, a leader. It pushed for action on the reduction of statelessness. In 1959, we find our representative, Mr. Ross, saying that to deprive persons of their nationality so as to render them stateless should certainly be an exceptional step, and the freedom of states to deprive persons of their nationality should be severely circumscribed by means of appropriate clauses in the Convention. So a very strong anti-deprivation position. This is the first stage of a conference that spread over 1959 and 1961. And the same year, another UK representative said the UK would have preferred to exclude altogether the possibility of deprivation of nationality in the case of natural-born nationals. But of course there were other countries involved. And they did in fact recognise that there would have to be compromises. And he said, Mr. Ross, that the UK would be willing to consider a general paragraph in this proposed treaty stipulating that a contracting party at the time of ratifying the convention might make a reservation in respect to deprivation of citizenship relating to any existing provision of its law. And I quote that because it resonates today. However, the United Kingdom delegation believed that fewer cases of statelessness would arise if a short list of grounds on which a national would be deprived of its nationality were included in the convention. And just to give you a sense of the overall flavour of the UK's policy position on that, Mr. Ross referred to the conference having a duty of doing its utmost to eliminate that minor cause of statelessness as well, that's to say deprivation of statelessness with respect to naturalised persons. The end result was Article 8 of the 1961 Convention, which does allow limited grounds for deprivation, and it confines deprivation further if it would lead to statelessness. Now, leaving aside fraud, this allows states, those states which have made the relevant declaration at the time of ratification, it allows them the option of depriving citizenship and making stateless the naturalised citizen who has acted in a manner seriously prejudicial to the vital interests of the state. So when we see those words reappearing in the UK legislation, it's clearly reflecting the intent to bring the wording of UK law into synchronicity with international obligations. But the other important thing to note is that the Convention also effectively froze the grounds for deprivation to those existing in national law at the date of ratification, and that's the UK's 1966. So basically what the UK has got to do is to bring its law back into the shape it occupied in 1966 when framing the grounds for deprivation of citizenship. No new grounds could be adduced, and there may be some room for discussion in one or another forum whether in fact such new legislation as may result does in fact do this job. What came next? Well, we've heard in great presentations already this morning and this afternoon from Helena and Matt, James and Amanda and Alice. We've heard a great deal, but I want to turn to Mrs. May, whom I now refer to as the alien. I now refer to as the alien in our midst. There was a very interesting debate on the 30th of January, and also incidentally on Tuesday of this week, on the 11th of February in Westminster Hall. But rather than quoting Mrs. May, what I prefer to quote is Pete Wishart, who I think has actually put his finger on a number of very important questions. In somewhat direct language, he noted, and I quote from his Hansard account, she, that's Mrs. May, could not start to answer the simple question of what happens to someone who is stripped of their UK citizenship but is not taken by any other country. Who is going to take these people? Are we going to launch them into orbit and leave them circling around the earth as stateless people without any sort of citizenship? Where will these people go? This is the big question that the Home Secretary has been unable to answer. What will happen to those people once they've been deprived of their citizenship? What will happen to their children or the people who depend on them? Another point that I want to refer to, it hasn't really got much traction at present, is this curious access to another citizenship issue. During the House of Commons debate, the Home Secretary said, and I quote from her statement, the important point is that the process applies in cases where the individual could access the citizenship of another country, and it would be open to them to apply for such citizenship. That, she said, is the whole point. Not if you read the draft it is, which makes absolutely no reference to this being any sort of qualifying condition for the exercise of the power of deprivation. So there does not appear to be any basis for this assumption, which, as you might recall, was part of the argument in the Supreme Court. The legislation then says nothing about accessing citizenship, which appears to be either smoke screening or wishful thinking on the part of the alien in our midst. In Jeddah, the Supreme Court made it absolutely clear that being stateless meant just that, not being regarded as a citizen of any state under its law. It did not cover the multitude of unpredictable alternatives, such as being eligible for citizenship or having the possibility of requesting citizenship elsewhere. The Supreme Court rightly concentrated on the facts as they are at the moment of purported deprivation symbols. Let me now turn to some of the international law implications of what is being debated at present. And for this purpose, I divide deprivation into, or I look at two aspects of deprivation. Deprivation as what I call an internal act, and deprivation as an external act. As an internal act, I'm thinking about the situation where a government does indeed strip an individual or a group of individuals of their citizenship in the sense of denying them the chance to exercise civil rights. And you might think prima facie, knowing what we know about the sovereignty of the state, its reserved domain of domestic jurisdiction, its presumptive entitlement to determine the criteria for citizenship, that such a move might be permissible, that it could deprive individuals of citizenship, deny them their political rights, access to social security, and so forth. But thinking a bit further, we would then say, yes, it could do that, but only if it did so according to law, if such steps were reasonably necessary in a democratic society, if they were proportionate, if they were consistent with the state's other obligations under international law. So I think there are quite a few criteria which would need to be satisfied from a human rights, from an international law perspective, before a state could move to render a section or an individual within its community of citizens without citizens' rights. But it's when we get to deprivation as an external act that we see the issues, I think, really coming into focus. As P. Wishart said, who is going to take these people? Are we going to launch them into orbit? Are we going to launch them into orbit? As a matter of international law, the correct position was set out in the House of Commons in 1960, when it was said on behalf of Her Majesty's government that no other state can be required to accept a stateless deportee, and that the power of deportation was not, therefore, available in a case in which a person's naturalisation had been revoked following conviction of espionage offences. A statement in the House of Commons 1960 in the case of Klaus Fuchs, who was one of the atom spies. He had sold or passed atom spies to the Soviets. He had previously, I think, had a connection with Czechoslovakia, but he was no longer a Czech citizen. He could not be deported. He did eventually leave and went to Czechoslovakia, but he could not be deported. And that is the situation in international law. The other side of it is readmission, refusal to readmit. So we know first that the UK cannot deport a stateless person to any country. But what happens if that stateless person, that person deprived of their British citizenship, seeks to re-enter? Or what happens if another country seeks to remove an individual previously British to the UK? Back in 1979, someone called Paul Weiss put out the second edition of his book, Nationality and Statelessness in International Law. And he pointed out the potential illegality to which deprivation of citizenship may give rise, particularly where, I quote, it affects the rights of other states to demand from the state of nationality the readmission of its nationals. Its extraterritorial effect, as to say the extraterritorial effect of denaturalization, would be denied as regards the duty of admission. And Paul Weiss was one of the early pioneers in statelessness studies. He himself was a refugee from Austria, he had been interned in Dachau, his sisters in Vienna got him out. He was lucky enough to be advised to get out of Vienna just before the Anschluss. He came to the UK, was naturalised a British subject, became a legal advisor in the International Refugee Organization, was the first legal advisor in the UN High Commissioner for Refugees Office, and ironically, for many years following his retirement, he was the United Kingdom's representative on the Council of Europe's Ad Hoc Committee on Refugees and Stateless Persons. So he did know a little bit about the subject. It follows from what I'm saying, and this goes back to good international jurisprudence, judgment of Judge Reed in the Notebook case amongst others. Any state which admitted an individual on the basis of his or her British passport would be fully entitled to ignore any purported deprivation of citizenship and, as a matter of right, to return that person to the United Kingdom. And if the United Kingdom were to refuse or seek to refuse readmission, and if no other country had expressed its willingness to receive that individual, then the UK would be in breach of international law. And you can just imagine the potential for damage to the UK's international relations if the alien in our midst goes ahead with multiple deprivations of citizenship. Think about, this may or may not be a good example. The gentleman whom we know is currently awaiting trial in jail in New York at the present time, Abu Hamza. Supposing the UK deprives this gentleman of his citizenship following enactment of this law, is the US going to say, no problem, we'll keep it? Well, they might do, although as Eric also mentioned to me, on the other hand, the US might be prepared to send him back to his country of origin, Egypt. But one can imagine other situations in which countries are not going to say that. Now, why should we have your people? You know, just because you call them stateless now doesn't mean that we should be responsible for them. But of course, I think the Home Secretary is probably hoping that anyone she deprives of citizenship will not go to the United States or a developed country or a country that might cause problems, but will go to some country that could be lent on in a new exercise of imperial will, a new form of imperialism. That, I think, hasn't been thought through, and I think it's one of the issues that hopefully will come up in the House of Lords, the potential damage to the UK which will arise through its disregard of basic principles of international law. And then there is the rights issue, and I just want to step briefly into the area of the European Convention on Human Rights, although we could extend it into the area of operation of other governments as well. Accompanying the last-minute draft legislation, the Home Office put in what I call a memorandum in justification, an attempt to cover its bases, paragraph 16, which fudgingly touches or appears to touch on the jurisdiction of the European Court of Human Rights, the potential that a deprived person might have to access protection under that convention. And it's cloud cuckoo land, it seems to me, for the Home Office or the Secretary of State to imagine, as this paragraph seems to suggest, that a person's European conventional rights can be annihilated simply by depriving that person of citizenship while he or she is abroad. The act of deprivation obviously only has meaning if it is directed at someone who is within the jurisdiction of the state. A citizen is manifestly within the jurisdiction of the state, and the purported act of deprivation of citizenship is clearly intended to affect his or her rights. So I see absolutely no problem whatsoever in the European Court assuming jurisdiction in any such case. What we have, sadly, again, is a situation in which we will find the Home Office and the Secretary of State wasting taxpayers' money, truckloads of taxpayers' money, as in the past, defending the indefensible, defending illegality, contemptuous of the rule of law, let alone human rights. Which brings me to wind up with the question of minimum safeguards. Are there any? Well, the best safeguard, of course, is no deprivation. That may not be feasible in the present climate, because I think the discourse on deprivation is linked to this horrible notion of citizenship as privilege, which it, in my view, clearly is not. Diane Abbott, in the Westminster Hall debates, referred to it as a fact, which got me thinking, but I'm not quite sure where it's going to lead me. Citizenship is not a privilege, it's a fact. But from an international law perspective, it reflects a link and a responsibility of the state, and that responsibility is something which states are not free to terminate unilaterally, certainly not in such a way as to infringe the rights or interests of other states. But I suppose if we're going to have to talk about minimum safeguards, then the first one is that it should, this measure of deprivation should never be applied to a person who is not physically present in the United Kingdom. There should be no removal or threat of removal unless there is a willing third state, unless there is a willing individual. And truly full account needs to be taken of family considerations, as we heard in some other cases mentioned today, and in particular the best interests of children and their Convention on the Rights of the Child rights, especially, not exclusively if they're British citizens. The UN in December recently issued a report, the report of the Secretary General on hopefully human rights and arbitrary deprivation of nationality in December last year, in which I learned, to my satisfaction, that a clear majority of states party to the 61 Convention have not invoked the Article 8 option, and they do not deprive a person of nationality on seriously prejudicial grounds if this leads to statelessness. The majority of states do not go the UK way. When it comes to effects and liability to expulsion, the report quotes the Human Rights Committee's General Comment 27 to emphasize that from an international law perspective, the link between the individual and his once country of citizenship continues. And that goes to the deportability point I made a moment ago. And finally, on due process, the report emphasizes that any review or appeal, I would fully agree with this, has to be suspensive. Nationality should continue until final determination of any process relating to the deprivation of nationality. And there must be access, which, as we know, is practically impossible or meaningless where the individual, him or herself, is outside the country. And if there is no effective access, then due process guarantees are, to all intents and purposes, nullified. Thank you.
Thank you. Take a couple of questions.
You want questions now?
Actually, with the time I see
this is
that.
actually just more of a comment than a question, so it could wait till later, but it was specifically about the dual nationality point.
Sure.
Just, I mean, this is for those, I guess it's for those people who are doing advocacy on this in the House of Lords. I mean, what the UK government is arguing is precisely what Mugabe has done, and I mention it particularly because Zimbabwe has a very useful advocacy potential in the UK, which is that all of these people who have a potential right to another nationality, because Zimbabwe does not allow dual nationality up until the recent constitutional change, therefore they are not Zimbabwean. And insofar as they've been given documents, that's in error, so we're not renewing their documents. And that's, because they have the potential right to Malawi and to Mozambique and to Zambia nationality, and of course British nationality as well. So it's exactly the same argument as Mugabe, which may have a certain utility in the House of Lords.
Assuming we're within the original declaration to the 61 Convention, so that what the Secretary of State is doing is what she could have hung on to in 61. The question is there any argument that because we ceased to deprive and make stateless in 2002, so ceased to use that declaration, that we cannot now revive it? If there is such an argument, if we fail to make it in Parliament, is it likely to be justiciable in Jeddah S2?
Yeah, I don't think so. I mean, I think there's a strong political argument. I don't think there's a legal argument built on that side.
So if I can turn to Eric Fitt, who is a barrister with Land Building, a specialist advisor and advocate in asylum, immigration and nationality work. He has also appeared before the Supreme Court and Court of Appeal in numerous immigration cases. He also chaired the Executive Committee of the Joint Council for the Welfare of Immigrants. And that's how many of us have come to know him as well. I'm going to turn to you now, and you're going to give us another perspective on European law.
Thank you. However, I'm not doing European law. That is Adrian. That followed us around. So I'm going to deal with public international law and with relevant parts of the law of the European Convention on Human Rights. And then Adrian Derry from Garden Court will deal with EU law. That seems sensible because, in terms of chronology, EU law related to nationality is much more recent, albeit, of course, extremely vibrant. You should all have a handout from me. So I'm going to try to avoid being wooden whilst taking you through that. The starting point is that nationality had traditionally been viewed not as a right of the individual. I mean, through centuries of history, it had been viewed essentially as an aspect of subjecthood and of the sovereignty of the ruler. And the public international law that we have reflects ongoing changes and developments as a result of which, for example, individuals have come to be much more recognized as the possessors of rights under international law. It's important, however, that the genesis of the system is essentially in a series of reciprocal relationships among sovereigns, going back to certainly the early modern period of the 17th century. More recently, in the early part of the last century, what the Permanent Court of International Justice held in the 1920s in the Tunis and Morocco case, which is foundational on this question, is, you see it on page 1 of the handout, paragraph 40 of the quote, the question whether a certain matter is or isn't within the jurisdiction of the state, within the jurisdiction of domestic law alone, is essentially a relative question. It depends on the development of international relations, and in the present state, in principle, questions of nationality are within that reserved regime. However, the court went on to note, already at that very early date, that the right of the state to use its discretion is restricted obligations which it may have undertaken towards other states. And so there are obligations among states which bind states in the way they dealt with their subjects. Looking back at that, it's important to register the fact that that is international law as between sovereigns before modern and especially post-World War II developments in human rights law and in individuals as a subject of human rights. In 1930, the League of Nations Convention on certain nationality questions, you have it page 2, it's for each state to determine under the law who are its nationals. This shall be recognized by the states insofar as it's consistent with international conventions, international custom, and the principles of law generally recognized with regard to nationality. You see Article 2 there as well. So, whether for the purpose of British law, you're a British national, depends on British domestic law, or United Kingdom domestic law. Whether that is recognized by other states, and whether that complies with the obligations that our state owes to other states, is a matter of international law, looking to the applicable treaties and conventions. So the court had said in Tunis and Morocco, the question of jurisdiction on nationality is essentially a relative question. That it's also very clear, as what emerges from what's called the Alabama Claims Principle, that the state isn't allowed to rely on its own law to avoid the international consequence of an act by it which breaches international law. So the UK can't point to its own statute as freeing itself from the obligations which bind it under public international law. Now, paragraph 5 of the handout, there are two areas of substantial recent development that are quite important in relation to this. First of all, following the upheaval, first of all, the many failures of the international law regime that existed prior to the Second World War, that was virtually at a point of breakdown by the time hostilities commenced in many respects. There was substantial development after the war. As someone whose professional genesis is as a refugee law practitioner, this is important to me, it's also important to all of you who are concerned about the development of human rights principles, because you have the international law of human rights essentially coming via post-war developments through the Universal Declaration 1948, later put into a binding form in the International Covenant of Civil and Political Rights. There is, of course, the other 1966 instrument, the Economic and Social Covenant, but for present purposes, it's the ICCPR that is of primary importance. And then you have third-generation rights instruments, like the Race Discrimination Convention, the Children's Convention, the Convention on the Elimination of All Forms of Discrimination Against Women, and more recently, and a good example of, if you look at these, of how the drafting has changed and how attention to this area has improved. You have the Disabilities for Disabled Persons Convention of 2006. But secondly, there's a body of law which isn't entirely concerned with human rights in the sense of giving rights to some people against their state, but sets up a hybrid regime, or a series of hybrid regimes, partly concerned with human rights, partly concerned with public international purposes in the traditional sense, as between states. And the two key examples for present purposes are the Refugee Convention, 51, and then the statelessness regime, by which I point to both the 54 Stateless Persons Convention and the 61 Reduction of Statelessness Convention. If you look to more recent instruments for hybrid regime characteristics, the trafficking regime that's developed in much more recent years is an excellent example. So, the key provisions: UDHR, not binding, para 6, page 3. Everyone has the right to a nationality. Sadly, that's not tied to anyone who has to give you that nationality, which has robbed this of utility, save for declaratory purposes. Article 15.2, no one shall be arbitrarily deprived of his nationality, nor denied the right to change his nationality. And Article 2 of the same instrument, the non-discrimination clause. ICCPR, 1966, and brought the binding instrument, that essentially drops the right to a nationality under Article 15.1, but it incorporates the right to protection from arbitrary deprivation of the right to enter your own country. Your own country is a formula that's been interpreted by the UN Human Rights Committee as being wider than the country of your nationality. In almost every circumstance, there's one exception I can point to in the cases. In almost every circumstance that includes at least the country of your nationality. The exception is provided by a New Zealand reference to the Human Rights Committee in a case called Tuala, which concerns someone who had been found to be a New Zealand national in a legal case that had established a right to New Zealand citizenship that hadn't been realized previously, essentially through a New Zealand legislative lacuna. That was then addressed by some swift New Zealand legislation to take nationality away. The question of deprivation was raised to the UN Human Rights Committee, which found that New Zealand hadn't become the own country of that individual who lived throughout I think it was Nauru or Tuvalu, through acquiring the nationality in that way. But that's an isolated exception. Broadly, if you've got the nationality of the state, that is your own country for purposes of Article 12.4, and you have ICCPR protection. That also extends to people who don't have nationality. In a couple of references from Canada and an Australian reference, there in the footnotes, the UN Human Rights Committee has said that extends certainly to, well, has hinted that does mean people who don't have the opportunity to naturalize or haven't themselves engaged in any derelict, or that has prevented them having the opportunity to naturalize in a country. The committee clearly considered it relevant that those were countries of immigration and assimilation, where access to nationality was relatively easy compared, for example, to, say, the Gulf states, Saudi Arabia, other states, where access to nationality, even on the part of long-term residents, is extremely difficult. So, own country, I've pointed to the UN Human Rights Committee's General Comment 27, at the foot of page 3, and the Australian case you have in Para 9. The Human Rights Committee has said that exile from your own country is effectively barred, and it's treated deprivation of nationality as within its remit, even if not expressly within Article 12.4, because deprivation of nationality is a potential means to bring about the exclusion from your own country. So, in responding to reports by signatories, the UNHRC has said that deprivation of nationality is within the ambit of Article 12.4. Article 12.4 referred to arbitrariness. So, under Article 12.4, you're not protected from deprivation per se. You're protected from deprivation where that is arbitrary. I tried to give a short account of Para 12. The scope of arbitrariness, you might all think, isn't fully established by present authority and thinking. The broad trend appears to be an expansion in a way that's broadly akin to administrative law principles and fairness principles. It certainly means a deprivation which is committed in breach, committed, for example, by the executive of your state or by others in breach of the national legal order. But it also means a deprivation which is objectionable otherwise, either because it's discriminatory in a way which is banned by the various instruments, or because there is an absence of due process. I've referred to a judgment of the Ethiopian Eritrean Claims Commission. That was an arbitration, so it can be treated like a decision of the International Court of Justice. It concerned proceedings between Ethiopia and Eritrea arising out of the conflict between them from 1998 to 2000, and the Eritreans claimed against the Ethiopians for resources they had expended in receiving and entertaining individuals deprived of nationality by Ethiopia. The findings of the Commission are far from perfect. The limitations of it have to be understood in the context of the evidence and the parties to the proceedings, the nature of the proceedings. But they did make a clear finding, which was subsequently of importance in this country, in establishing deprivation of nationality as persecution in many circumstances, that the deprivation of persons who were permitted to remain but reduced within their own country from national status to alien status was arbitrary given the absence of due process and was a breach of international law. Considerable importance was given to the fact, by the way, that took place in a time of armed conflict, albeit, someone here may be able to correct me, but to recollection, Ethiopia had never exercised any derogation from ICCPR, the outbreak of hostilities, and indeed Article 12.4 is not an article from which derogation is permissible under Article 4 of ICCPR. I've set out one by one the third generation instruments, beginning with the Race Discrimination Convention, Convention on the Right to the Child. I'm conscious I'm between you and Scott, So, Children's Convention, para 17, linked to Scott. Sea law, para 18, the Discrimination Convention, para 19, and you see Article 18(1)A of the 2006 Convention. Persons with disabilities have the right to acquire and change their nationality, and are not deprived of their nationality arbitrarily or on the basis of disability. So if you had a situation that was, say, akin, say for discrimination being on the basis of disability rather than national origin, to that which the Inter-American Human Rights Court considered in the case of Yin and Bosico, where individuals were refused documentation as being born in the Dominican Republic, by the Dominican Republic. That resulted in them being unable to prove entitlement to the Dominican Republic nationality. All of them would technically be refused nationality on the basis of evidence and entitlement to it, through the absence of a birth certificate, which they then refused because their families were from Haiti. It's very clear from that decision, taken together with the other international instruments, that approach is prohibited. That approach is expressly prohibited in relation to disabled persons. You see by Article 18(1)A there. And so that you can see, I would respectfully suggest that you can see the signs of a crumbling at the edges of the absolute nature of sovereignty, a more balanced approach to national exclusivity and sovereignty in the materials, and also an appreciation of some of the cases and situations that are happening over relevant time. Yin and Bosico, important decision under the regional instrument, Power 20, and then international refugee and stateless instruments. Power 22, I mean, these are the hybrid instruments, the hybrid regimes. I respectfully regard them as separate, though intertwined and perhaps overlapping hybrid regimes. The Refugee Convention, it's not noted here, but it's now well established, certainly in this country and in Germany and also in New Zealand, that a deprivation of nationality, which is arbitrary in international law terms, that is, which is a breach of Article 12(4) ICCPR. A deprivation of nationality which is arbitrary and which is motivated by one of the reasons listed in the Refugee Convention, Article 182, and which isn't a deprivation of an extra nationality, as it were, which deprives you of nationality and leaving you stateless. It's essentially trade law now in those three significant jurisdictions that makes you a refugee if you satisfy the conditions, you're outside your own country, and so on. The statelessness regimes, Articles 8 and 9 of the Convention on the Reduction of Statelessness, 1961, Guy referred to those in his remarks, so I've set them out there. So, Article 8 is the bar on Article 8(1), and bar on deprivation of nationality that would render that person stateless, and 8(2) was the limited, the remainder set out limited bases on which a state might exercise a power of deprivation, which were referred to by Guy, and so in the interest of time, I'll move on. Regional instruments, the European Convention on Human Rights. The European Convention, of course, was signed in 1950. It was composed in the post-war period, where, notwithstanding the events of the war, you still see a considerable overhang of respect for sovereignty, for the interests of states in international lawmaking. That's reflected in the European Convention. The range of rights it provides that are directly addressed to nationality is extremely limited, though some rights are relevant. Articles 3 and 8 may be relevant. Article 14, it's discrimination in relation to the other convention rights. Of course, discrimination justified the decision of the East African Asians case that there was a breach of Article 3 in the exclusion by Britain of East African Asians whose British subject status had been rendered ineffective to assure them entry at a time when they were deprived of their homes in East Africa by the governments of those states. The Article 8 standards have been applied to statelessness, to the consequences of statelessness in a number of cases with mixed results. The most important cases being Slovenko, Sisojeva, Kuric against Slovenia, Power 29, in relation to measures in Slovenia following the collapse of the Soviet bloc, which put ex-citizens of the former republic of Yugoslavia into, I'm sorry, not the Soviet bloc, but ex-Yugoslavia, which put ex-citizens of the Soviet former republic of Yugoslavia from non-Slovenian parts of the territory into a significantly disadvantaged position. Courage and a useful and important case, but at the same time illustrating the relative limitation of the European human rights provisions in relation to nationality. Optional Protocol number 4, not ratified by the UK, Power 30, and Article 3 of the Optional Protocol provides no one shall be expelled by means either of individual or collective measures of the territory of the state which is national. No one shall be deprived of the right to enter the territory of the state of which he is a national. And in the light of current events, of course, you may wonder why the UK isn't ratifying this. It's an open question. There we are. European Convention on Nationality, also a Council of Europe instrument rather than an EU instrument, and therefore within my bid rather than Adrian's bid, set out in the remainder, and that provides another set of useful limitations. The UK is not a signatory, but certainly has in the past aspired to become a signatory. As I understand, we've stopped aspiring for the moment, but let's hope change. So that's my bit.
Okay. All right. Well, we're going to look at EU, the role of EU law and the deprivation of citizenship. Really, the question for us today is what is EU law going to do for us? We want to stop people being deprived of citizenship, and the omens are not good. There's obviously a bill in Parliament which can leave you stateless, and UK domestic law, parliamentary sovereignty permits that. If Parliament passes a law in a dualist system in our domestic order, that is the law. And so we have a range of international instruments which we've been looking at. We have the 1961 Convention on the Reduction of Statelessness, we have the unsigned, unratified European Convention on Nationality, and we have various instruments which we have incorporated into domestic law, the Human Rights Convention. That's all well and good, but none of this is really taking us anywhere. People are going to be left stateless on the result of the amendment at the moment as things stand. But we do have one source of international law, which is creates justiciable rights, and the rights which can be directly effective in national courts, and that's European Union law. We have two interstate treaties, the Treaty on European Union, the Treaty on the Functioning of the European Union, both of which are received into national law via the European Communities Act 1972. And does that make a difference? The starting point is, of course, that nationality law, the right of a member state to set the rules for the acquisition and loss of its nationality, is within the reserved domain of states. It is something which, when European Union citizenship was created in 1992 in the Treaty of Maastricht, There was a declaration, Declaration number 2, which specifically makes that clear, and a statement from the Edinburgh Summit. At that time, it was expressed slightly differently in terms of citizenship of the Union was a complementary status. Following the adjustments in the Treaty of Lisbon, it's now an additional status. It jumps on top of membership of the nationality of a member state. It's an additional thing, but in order to be, at present, a European Union citizen, you have to be a national of a member state. And so, on the face of it, there is nothing to disturb the analysis that the acquisition and loss of nationality of a member state is a matter for the law of that state. But we do have, it is a status which is ostensibly separate. In order to be created, it requires you to be a national of a member state, but then it starts to have its own logic. And the common theme, if you like, about what EU law can do for you in deprivation circumstances is that the Court of Justice is concerned with the authority and the autonomy of the European Union legal order and will protect any status which relates to that. And you see that in another example which we can look at in the Cardi and Al-Barakat case, the first one to reach the Court of Justice, where, if you remember, that was about freezing the assets of people pursuant to European Union regulations, which were themselves made pursuant to UN Security Council resolutions. And the Court of Justice famously said, well, fundamental rights mean that you have to have certain fair procedures in order to do that. But they didn't say fundamental rights as they arise in the international legal order, they said in the European Union legal order. And so the right result was there, but not by reference to universal rights, but to rights as they take effect in the EU legal order. And in the same way as the EU likes to protect fundamental rights as an incident of EU law, so too does it like to do so protect citizenship, because citizenship, as created at the level of the Union, is a status within the European Union legal order, which it conceives, the Court of Justice conceives, has its own legal effects. And you see that EU citizenship has a statutory context. It isn't empty in the way that British citizenship is almost an empty shell, but for giving you the right of abode under Section 2 of the Immigration Act 1971, British citizenship would give you nothing. It has no statutory rights at all. It's a very thin category. EU citizenship, as an additional status, gives you a range of rights: the right to move and reside freely, vote in municipal elections, receive consular assistance in a state outside the EU from another member state's authorities on the same conditions as the national of that state. You can petition the Parliament and the Ombudsman and do all kinds of things. But the fact is that there are some things there that mark it out as a separate thing. In that context, we have the case of Janko Rockman against Freistaat Bayern, which is a case that which I like for a number of reasons, not least because it was promulgated on my birthday. As a nationality lawyer, I could want for no greater present from the Court of Justice than this fabulous case. But what it has and what is at stake there in that case is whether or not, notwithstanding the fact that a state can deprive someone of citizenship in order of its own nationality in order to make that person stateless, nonetheless there's a role for EU law in protecting the EU citizenship that a person additionally stands to lose. And the case in that case, as is well known, there was an Austrian gentleman who was wanted for fraud in Austria, and he rightly decided that if he remained in Austria, he would like to be subject to the criminal justice system, moves to Germany to escape, naturalises as a German, fails to mention that he's wanted in Austria for the fraud offence with which the warrant is out for his arrest. And so he's naturalised as a German, and of course he was an EU citizen as an Austrian, and then when he's naturalised as a German, by automatic operation of Austrian law, he loses his Austrian nationality. The Germans, or the Bavarians, find out that he's not being entirely candid with them about his reasons for moving to Germany and naturalising, and take steps to deprive him of his German nationality. And the consequential effect of that will be that he will be left stateless if it takes effect. But equally, he would also lose his European Union citizenship. So you can see at the outset that there is an element of free movement. Factually, he has moved from Austria to Germany, but his German citizenship has arisen wholly within the context of a person being in Germany. He, as a person lawfully resident in Germany, he naturalised in Germany. So he'd been an EU citizen before he moved, he was an EU citizen after he moved, but by reference to a different member state nationality. Now, the default position in EU, in international law, in relation to who determines the role of a state in determining its own nationality and the question of recognition of that. It is, as we've already covered, Article 1 of the 1930 Hague Convention relating to questions on the conflict of nationality law, that it's for the member state to determine under its own law who are its nationals. That seems pretty clear. And that this law shall be recognised by other states, insofar as it's consistent with international conventions, international customs, and the principles of law generally recognised with regard to nationality. So there are two elements there. The state in question determines under its own law who its nationals are, and then secondly, there's if you like, a rule of recognition characterised in a certain sort of way. The problem in deprivation of citizenship context is that those international conventions may permit you to leave a person stateless, as the 1961 convention actually does. And so what do you do if you get no protection from this sort of arrangement? There's nothing necessarily wrong with leaving someone stateless in the prescribed situations in the 1961 convention. Convention compliant. The provision is made for it. We know, as a statement of intent, we know what Article 15 says in the Universal Declaration of Human Rights, that no one shall be arbitrarily deprived of nationality, and we know that the Convention on the Reduction of Statelessness makes provision for deprivation, notwithstanding that a person would be left stateless in circumstances where the appropriate reservation has been entered at the time of ratification, where a person has conducted themselves in a manner seriously prejudicial to the vital interests of the state. You're not necessarily going to get anything from that bit of international law. The European Convention on Nationality, which of course the UK has neither signed nor ratified, nonetheless sets a series of benchmark standards in the European regional system, which you might say, which the Court of Justice certainly takes seriously in the Rockman decision, although it's right to say that both Austria and Germany were signatories to this convention. And you see there in Article 3 of the European Convention on Nationality.
Sorry, Adrian, did you say they were or they weren't?
They were. And you see there in Article 3 there, the modern restatement of Article 1 of the 1930 Convention in relation to questions concerning nationality. The wording is slightly jigged around, but the same principles apply as in Article 1 of the 1930 Convention. And there, in the European Convention on Nationality, you see that the provisions that you can deprive somebody of nationality if it was acquired on grounds of fraud, also on conduct seriously prejudicial to the vital interests of the state, but you can only do so if they would therefore become stateless on fraud grounds. So it's more restricted than the 1961 Convention, because conduct seriously prejudicial to the vital interests of the state is a ground for deprivation, but not to be stateless. Well, the UK hasn't signed up to it anyway, so it cares to some extent. But it matters if the European Court of Justice takes it seriously when it comes to review a deprivation decision on grounds of proportionality. Because if it forms part of the corpus of international law received into the EU legal order as a necessary basis for reviewing a decision to deprive someone of the nationality of a member state and therefore thereby of European Union citizenship, then it may be a benchmark standard by which to measure the proportionality of any particular decision. Now, of course, Rockman's decision for deprivation on grounds of fraud, not on grounds of conduct, but nonetheless, the judgment itself has resonance for how to go about assessing the proportionality of deprivation provisions. And so what they're wrestling with, what the Advocate General in Rockman is wrestling with, and what the Court is wrestling with in Rockman, is how do we relate this idea that nationality is within the reserved domain of states, but nonetheless, depriving someone of nationality will also make that person lose their European Union citizenship. And the Advocate General, Maduro, starts off by having to confront this problem. What does international law give us outside of the EU law being part of international law? And does the EU legal order make any difference? And so the Advocate General starts off by considering the question of this relationship between nationality and EU citizenship, and says, well, it assumes the nationality of a member state, but is the legal and political concept independent of that nationality. It forms the basis of a new political arena from which rights and duties emerge, which are laid down by community law and do not depend on the state. And there you see at the bottom of the extract there, this in turn legitimises the autonomy and the authority of the community legal order, just as in the same way as the reasoning in the Cardi and al-Barakat decision was done by reference to fundamental rights as they take effect in the European Union legal order. And so you see, as it continues, whilst nationality of a member state is a precondition for access to union citizenship, the body of rights and obligations associated with EU citizenship can't be limited in an unjustified manner. Justification is required. The conditions for the acquisition and loss of nationality must be compatible with European Union rules and respect the rights of the European Union citizen. So the reason it's an EU question for the Advocate General isn't because it's a competence question. It's clearly not. The European Union doesn't have competence in question of nationality. The reason it's an EU question is the mode of acquisition and loss must be compatible with whatever EU law prescribes in respect to EU citizenship. So it's a compatibility question. A tempting thread is left dangling about another general principle of EU law, about the principle of protection of legitimate expectations, but it's not taking any further on the facts of the case. And then we end up in the position of what are the principles to be applied. Now, there was this prior case of Micheletti from the beginning of the 1990s, and that was a case where there was a man who was a dual national. He was Argentinian and Italian, and he wanted to practice as a dentist in Spain. He went along and thought, well, I've got these free movement rights, that's excellent because I'm Italian, so I can just go on to Spain, I can be a dentist, and what's wrong with that? I can work there. It's about freedom of establishment in the place. And Spain had this position. They said, well, if you have two nationalities, we want to see which one you really have a genuine link with. And in cases of multiple nationality in international law, we're all very familiar with that sort of thing. We're going to look at your country of prior habitual residence. That's absolutely fine. That's unobjectionable in international law terms. If you have to decide between two nationalities, which one you're going to recognise, a genuine link, such as habitual residence, is fine. And to make that kind of assessment would be consistent with general principles of international law as they apply to nationality, and so consistent with Article 1 of the 1930 Hague Convention. So it wouldn't take you any further. But EU law intrudes further and does something. It says, well, that's all very well, and that rule of recognition, which we looked at in Article 1 of the 1930 Convention, is fine, but it interferes with an EU right, freedom to provide, freedom of establishment, free movement right in this case. And so a member state can't impose an additional condition for the recognition of that nationality, even though that very condition of recognition, what was the country of your former habitual residence, is the sort of genuine link, which is generally speaking unobjectionable in cases of multiple nationality. And so here you see the beginning of the idea of the EU legal order, albeit part of international law, actually creating its own juridical space, its own idea about how nationality law is going to be understood and received, and how it's going to have, because it impacts on rights. All these rights, remember, are justiciable in the national context in member states. And so we then turn back to the judgment in the Rodman case, having set the groundwork that EU law does something different with nationality law to what international law generally does. And we look at the question of is the Rodman judgment really about a cross-border element, so it's within the scope of EU law because there is free movement, or is it, in a sense, a single-state case or a wholly internal case? Is there something there? And what the court says here is the court does not use the reasoning of free movement. It's true the Advocate General has huge anxiety about this when you read the judgment, but when you read the opinion. But in the judgment, the view of the court is that the loss of EU citizenship, the loss of the nationality, puts the person in a position capable of causing him to lose the status conferred by what is now Article 20, citizenship of the Union, and the rights attaching to it. And the rights attaching to it therefore falls by reason of its nature and consequences within the ambit of European Union law. The reasoning is not by reference to free movement, but by reason of its nature and its consequences, it falls within the ambit, within the scope of EU law, notwithstanding the want of competence on nationality law issues. And so this comes up with this sort of formulation that you originally find in the Micheletti case about member states, when exercising their powers in the sphere of nationality, must have due regard to nationality law. And this was the observation which caused Lord Justice Laws in the G1 case. He just did not understand what does it mean to have due regard to European Union law. Well, he should know because he's a clever man, and it's explained in the Rockman judgment. So it's not hard really. As we'll come on to see, in fact the judgment is quite straightforward on this about what due regard means. And in some senses, it's a process right. It introduces, if you like, a pause, a proportionality assessment, a moment to allow you to recover a prior nationality. It doesn't necessarily tread into the ultimate reserved domain of member states. In the final analysis, can you deprive someone of nationality? But it says along the way, you will have to consider certain things, and there may be circumstances where you are going to have to halt that process prior to doing it in order to protect the rights of the EU citizen. And you see that what the court says, due regard must be had to European Union law. This does not compromise the principle of international law previously recognised by the court, i.e. that member states can determine the conditions of acquisition and loss. Insofar as it affects the rights conferred and protected by the legal order of the EU, and as in particular the case of a decision withdrawing naturalisation, such as at issue in the main proceeding, it's amenable to judicial review carried out in the light of European Union law. Now, in some states where proportionality is a doctrine of principle of administrative law, it may not add a huge amount of value. But in the UK, where proportionality generally requires something else, something extra, whether it's in human rights or whether it's about access to the courts or whether it's about EU law, that's a statement of real value. But nonetheless, the court says, well, you can, of course, take the public interest into account, and clearly where you've acquired nationality by fraud, that's going to be a legitimate public interest that needs to be looked at, about not being party to a fraud. But the court notices, as you see in paragraph 52, that nothing is derived from our other international instruments that we've been looking at, the Convention on the Reduction of Statelessness or the European Convention on Nationality, because if you've acquired citizenship by fraud, those conventions provide that you can be deprived of that citizenship even if it would be stateless. So from the remainder of international law, you get very little. And of course, it's not arbitrary to deprive someone of their nationality where it's obtained by fraud either. So the considerations, though, if you look at paragraph 54, in principle, withdrawing naturalisation on account of deception, the conditions of the legitimacy of doing so remain valid, even where you stand to lose citizenship of the Union as well, EU citizenship. However, and this is the important bit, of course, there are two bits in paragraph 55 which are important. Firstly, you must observe the principle of proportionality as far as it concerns the consequences in the light of EU law, and in addition, where appropriate, proportionality of the decision in the light of national law. So there are two bits which the court thinks drivers there of bringing proportionality into the frame. And then in paragraph 56, they put flesh on the bones of that it's necessary to take account of the consequences of the decision for the members, for the person concerned, for the members of their family, with regards to the loss of rights enjoyed by a citizen of the Union, and necessary to establish whether it's justified. Again, justification is required in relation to the gravity of the offence committed by the person, so you're measuring that, the lapse of time between the naturalisation decision and the withdrawal decision, and particularly a very important procedural right where you're about at risk of statelessness, whether it's possible for that person to recover his original nationality. And you don't find a procedural right quite like that anywhere else, which is justiciable, potentially. So as part of a proportionality assessment. So that is of real value. And all the relevant circumstances must be taken into account. In observance of the principle of proportionality, the person concerned must be afforded a reasonable period of time to recover the nationality of his member state of origin, bearing in mind that, of course, there were the nationalities of two member states in that case. And so we see there that the idea that the decision is subject to judicial review on the question of its impact, the degree of interference with European Union law, the question of proportionality of the measure, both on the impact with EU citizenship and national and proportionality as measured against national law, the question of measuring the impact in terms of the seriousness of the infraction, the impact on family members, the question of a pause to allow you to recover a former nationality, or even proportionality assessment, the categories are not closed, why not to acquire the nationality of another state which you may be entitled to apply for? Why simply just the state? I mean, Rockman, on the facts of the case, it was the nationality of Austria, the country of a former nationality, but it need not be so. The real measure of procedural protection on the face of it. And so, although it's not precluded in the final result, the member state can, in the exercise of its sovereign power, deprive you of nationality, that must be compatible with the principle of proportionality as it takes effect in the European Union legal order, because of the impact on EU citizenship. And various people have commented on this in the literature. If you look at Kochenov's observations, that his approach is that Rockman assumes the cross-border approach, which is not the view that Lord Justice Laws took in the G1 case, and focuses on the intensity of the interference with the rights of EU citizens. And that's, in my view, a good way of looking at it. Taken together with subsequent cases such as Zambrano and McCarthy, which are obviously looking at whether or not an interference which interferes with the genuine enjoyment of the substance of the rights of the EU citizen. He draws together the 6 points about where EU citizenship is taking us at the present time. That what you're beginning to see is greater coherence because you're using EU citizenship in a way that gives a coherent status to people who are subjects of union law. It's creating a real substance to it. And because you're not relying on things like whether or not it touches on free movement or employment or any other area within the competence of EU law, what's beginning to emerge is a more substantive approach to the issue of equality within the EU. And it's also creating if you like, a single judicial space within the EU in terms of the unity of the territory. Hitherto, the European Union has no territory of its own, it just has the territory of its member states. And then, of course, there are internal subdivisions of jurisdiction within that. But what you're beginning to see with Rockman and with Zambrano is a common European space, which creates problems for member states, which they've not anticipated, and obviously a degree of resistance and uncertainty. Other commentators, Professor de Groot in the Netherlands has observed that the impact on the national laws of member states may be greater than first thought. That, and in his view, deprivation on fraud grounds prior to the opportunity to reacquire a previous nationality may be prescribed, and there may be a requirement for the deprivation not to be effective immediately. Again, very sensible, very obvious. Once you go down the proportionality route, the idea of a procedural pause before doing that, and of course he sees the right of legal challenge as inherent within it, which in some states, whether as the provisions may have, or where access to the courts is highly restricted in terms of funding or in terms of closed procedures, the question of what constitutes a right of effective legal access, a challenge may be a live issue. And then Professor Shaw in Edinburgh looks at the context of Germany, and then there, if you acquire nationality, then perhaps stand to lose it, because you then, as you get older, you're a multiple national, you opt for you still rely on the nationality, another nationality you've acquired by descent, then you might lose EU citizenship. The nationality you've acquired by descent is a non-EU, it's from the nationality of a non-member state. And then you lose German nationality as a result of relying on your other nationality, you would lose EU citizenship. Is a law like that compatible in that context? And also, she sees a requirement for reasons. And what we see coming out of this as a whole is a degree of procedural protection, which in the light of Amanda's presentation seems quite useful. I mean, you think that's a good idea until you come to read what Lord Justice Laws says, which is a case that Amanda was in the key study. He has huge difficulty with all of that, and takes the view that I'm none the wiser as to the juridical basis of the obligation to have due regard to the law of the European Union. It comes from Micheletti, it's been there since 1990. The idea is that you have to look at it in terms of its impact on EU citizenship. He places great store on the fact that the distribution of national citizenship is not within the competence of the European Union. Something the Court of Justice was well aware of, both in Micheletti and in the Rockman decision. And then he says, well, there's no cross-border link in this particular case, and therefore, and again, the reasoning in Rothman the ratio, the way in which the court approaches the answer to the question, doesn't rely on the necessity for a cross-border link, in my view. So, of course, the view of the Court of Appeal is binding in this jurisdiction, so it's a challenge, obviously, to, without a reference to the Court of Justice from SIAC, which is about as likely as being hit by an asteroid, it's going to be very difficult to overturn that case. But you can see that there is a real conflict between the way in which EU law, the Court of Justice has approached the issue of how to look at principles of nationality law in the light of obligations in the EU legal order, and the approach that the Court, the reference to the G1 case, by the way, that is not on the slides, is 2012 EWCA CIV, that's CIV 867. And you can see that there's a real tension between the principled way in which the Court of Justice wrestles with adapting the principles of nationality law and receiving them into the European Union legal order, whilst at the same time protecting rights which arise within that order, and the approach of the Court of Appeal of England and Wales, which is largely to say, well, it doesn't make any difference. And then you heard Amanda's comment that about the start of that they weren't particularly impressed with the appellant in that case because they thought he was a fugitive from justice. But it's not necessarily G1 who's a fugitive from justice in the light of reading the Rothman decision. It might be the judgment of the court because it hasn't approached the proportionality assessment in the way that the Court of Justice requires the national court to do as part of the duty of sincere and loyal cooperation under the Treaty on European Union. Thank you very much.